Around mid of 2017, uh, there was an incident in Greater Noida involving Bangladeshi nationals who had attacked a gated community in Noida. And an issue which was until then under the perhaps on the back burner and was festering under the surface had suddenly come to the forefront and had suddenly grabbed the national headlines. It is sad that unless and until people in Delhi are affected, that certain issues don't get the limelight they deserve or the attention they deserve. And perhaps the issue of Bangladeshi immigration had finally announced its arrival in perhaps the most unlikeliest of manners through this incident. But then, has it translated to any action? Has it any bearing on an existing news spec such as the Rohingya crisis? What is the state's response to this particular threat? What kind of a threat does it actually pose to the Indic civilization as we know it, to our way of life? What kind of a security threat does it pose to us? What should be India's legal response in light of the constant calls for India to take on board all these refugees, as they call it? Whether India recognizes the category of a refugee under its legal framework? What are the principles of international law that apply to this situation? What should be India's response? Whether it should place its domestic interests above and over the dying need for appearing a statesman nation. These are some of the issues that I intend to address as part of this talk. Who are Rohingyas? Who do they represent? What is their worldview? Let's try and understand this in the first place. I happen to be part of the team which is representing the Indic Collective Trust before the Supreme Court in an intervention petition in an ongoing proceeding filed by Mr. Prashant Bhushan on behalf of Muhammad Salimullah, a Rohingya Muslim, asking for a stay on the government's direction on the deportation of Rohingyas from all parts of the country. Now, as on date, the stated official figure happens to be that there are 40,000 Rohingya Muslims in India, out of which around 16,000 are concentrated in perhaps the most controversial flashpoint this country knows as on date, which is Kashmir. And they're not even in Kashmir, they happen to be in Jammu. Why do they happen to land in Jammu? How is it that from Burma, leaving all the states in the northeast, they find their way to Jammu and Kashmir is a question that needs to be answered. Now, this petition, when it was filed before the Supreme Court, we were the first interveners to approach the Supreme Court to support the decision of the government, and also blaming the government for having let things to arrive at such a pass, where there are at least 40,000 people going by the official figures. And if the official figure is around 40,000, my sense as an Indian citizen tells me that the figure is bound to be more than 40,000. Out of this 40,000, apart from the 16,000 who are present in Jammu, a good number of them are present in distant and farther parts of Tamil Nadu, in Hyderabad, in Maharashtra, and God knows where else. And it is indeed surprising that we have a national security advisor who is supposed to be a former super spy who claims to have spent a lot of years undercover in Pakistan, that under his watch we have so many Rohingya Muslims entering the country. Now, the position that we have taken before the Supreme Court is, without exception, each and every one of them must be deported back to their country, or at least to Bangladesh at the very least. And they must be given the resources or the humanitarian aid they need to lead a dignified life, but certainly not in India. This position has come under attack from several quarters, most of them calling us fascist, bigoted, communal, and the usual terms that are attributed to any position, which are not necessarily left of center. And we've been told that we are heartless, and thankfully we have not been called brainless so far, which would have been our problem. The position that we have taken is simply this: the 40,000 people who have landed in this country, they may not be terrorists, and perhaps all of them are not terrorists. Be that as it may, there is no need for India to invite them and hug the cactus, especially in light of the bitter lessons that it is yet to learn from its experience with Bangladeshi illegal immigrants in this country. As far as we are concerned and as far as our reading of the situation is concerned, the Rohingya Muslims perhaps represent a continuum and the second wave of illegal immigration with a greater claim of legitimacy than Bangladeshi illegal immigrants. And therefore, it becomes important to understand the nexus between Bangladeshi illegal immigrants and Rohingyas to some extent. There is an ethnic nexus here. Some of these news peddlers would like us to believe that Rohingyas is an ethnic term which applies to Hindus as well as Muslims. But the fact of the matter is, a lot of scholars, including Burmese scholars who have been researching on this particular issue for decades together, have come to the conclusion and have enough basis to support the claim that Rohingya is an ethnic term that was coined by Bengali Muslim intellectuals to represent themselves, and that Rohingya is equal to and synonymous with Rohingya Muslims and not Hindus. This much is clear. And in fact, the Rohingya Muslims trace their origins to Chittagong as evidenced by colonial records. So for all practical purposes, these are Bengali Muslims. And as history tells us, a good number of them decided to join forces with, or at least throw their weight behind, the idea of Pakistan and not the idea of India. And therefore, to me, it doesn't make a difference whether they come from Burma or they come from what we know as Bangladesh today or erstwhile East Pakistan. The fact remains that their worldview resonates with the worldview of Pakistan. Their ideology resonates with the ideology of Pakistan. They wish to live in an autonomous Islamic region, if not at least, or their original goal seems to be the creation of an Islamic state. In fact, the history of the Rohingya crisis in Burma goes back to 1948. And the creation of an exclusive Muslim enclave has been at the heart of the issue, has been an issue which is perhaps comparable to the Kashmir issue as far as India is concerned, and the timelines almost match. So when in 2015, we suddenly find that a Burmese militant by the name Chhota Burmi, and this was reported in the Tribune, is killed in action in Kashmir, it ought to raise our tentacles, it ought to raise our hackles, and it must certainly bring creases of concern on our foreheads for the simple reason that it represents another wave of illegal immigration. Now, why do I call it another wave of illegal immigration? The answer to that is very simple, and one has to just take a look at the Assamese experience in terms of how illegal immigration has devastated and destroyed the culture of that particular state, and perhaps not just Assam, other parts of Northeast as well. And this goes back right until I think to the 1950s. Immediately after the creation of Pakistan, which is West as well as East Pakistan, India noticed that there was a deliberate design for creating a greater Bengali Muslim land, and which is why it led to immigration, illegal immigration from erstwhile East Pakistan and the place that we know as Bangladesh today, into parts of Assam and other places, which is why it led to the promulgation of the first legislation, which is the Expulsion of Illegal Immigrants Act of 1950 by the state, to kick out illegal immigrants who were entering the state of Assam and other places. So this happened in 1950. Subsequently, in the aftermath of and in the backdrop of the 1971 war and the persecution of East Pakistanis by West Pakistanis, particularly because of their ethnic origins and their affinity to the Bengali language, India saw an influx of millions of Bangladeshis into India. And this went on unabated despite an accord having been arrived at in 1972 between India and Bangladesh, between the heads of the state, namely Ms. Indira Gandhi and Mujibur Rahman. Despite that, it continued unabated. And slowly this resulted in the creation and fomenting of unrest in the state of Assam. Because one of the fundamental bedrocks of the relationship between Assam and India otherwise was that the native culture shall be protected, the indigenous culture shall be protected. In fact, this kind of an arrangement has been entered into by the Indian state with most of the northeast states, such as even Sikkim and Arunachal Pradesh, which is to say that no foreign influence shall be allowed to dilute the presence of the native culture, the indigenous culture. Having given this solemn sovereign promise or a pledge to these states, India reneged on these promises by allowing infiltration to continue unabated. And this ultimately snowballed into what we know as the Assam unrest, where the Assam Student Union was created. This also led to the creation of a multiple number of militant groups and terrorist groups such as ULFA, most of whom were fighting to protect the Assamese identity. It is sad that a state which withstood the onslaught of the Mughals and which managed to retain its native identity when the rest of the country was reeling under the onslaught of the Mughals, had to ultimately suffer a loss of its identity after the creation of an independent India under an Indian government, so to speak. And this is exactly what has happened with Assam. Most official figures as on date say that the figure of native Assamese population hovers in the whereabouts of perhaps 50 to 60%, which means close to 50% of the population is non-indigenous in nature. And this has happened over the years. To address this problem, one would have hoped that the Indian government would have taken active measures to deport illegal immigrants. This takes us to the question of what mechanisms are available to the Indian government to deport illegal immigrants or foreigners. There are two legislations that apply to this issue broadly under the Indian legal framework. The first is the Citizenship Act, and the second is the Foreigners Act. The Foreigners Act vests the government, the union government, with the sovereign power to evict illegal immigrants who end up coming to this country without appropriate documents or who end up overstaying their period of allowance as far as India is concerned. In both these circumstances, the government has the power to deport them. In addition to that, the Foreigners Act also gives the government the power to set up tribunals to evict foreigners or illegal immigrants if they have entered this country en masse. One would have hoped that the government would have used its powers under the Foreigners Act, which the Supreme Court has held as almost supreme, to the extent that nobody can interfere with these powers simply because it happens to be a sovereign power and it comes with the concept of a nation state. One would have hoped that the government would have used these powers to secure the interest of this country, to secure the borders of this country, to secure the native identity of Assamese and the entire Northeast. Instead of constituting foreigners tribunals under the Foreigners Act, the government chooses to come out with a different legislation known as the IMDT legislation, which is the Illegal Immigrants Determination by Tribunals Act of 1983. Now, this act was brought about as a placatory measure to try and assuage the concerns of the Assam Students Union to some extent, to say, "Hum is विषय में कुछ कर रहे हैं," is more or less the response of the government, and therefore the shambolic piece of legislation was brought about. The funny part about this legislation was that on paper it was meant to facilitate expeditious deportation of illegal immigrants. But in reality, what it facilitated was greater delay in deportation of illegal immigrants, because by the time this tribunal was set up, there was a sizable number of Bangladeshi Muslims who had entered Assam and who constituted a major vote bank as far as our politicians is concerned. And this is not a political rhetoric. This is a fact that has been recorded in the judgment of the Supreme Court. In the first Sarvanan Sonowal decision on this particular issue, where the court was seized with the issue of the constitutionality of the IMDT Act. So the IMDT Act, as opposed to playing the role of a facilitator of deportation, was in fact encouraging deportation for the simple reason. And how does it do so, or how did it achieve this particular object? Let me just explain this. So under the Foreigners Act, a person who is suspected of being an illegal immigrant, it is for him to establish how and why he is otherwise a legal migrant or he is a citizen of this country. The burden is on him. But as far as the IMDT Act is concerned, not only is the burden reversed, the burden is also spiked in height, wherein it is the greater burden of the state to prove that a certain person is an illegal immigrant. And consequently, each of these proceedings would drag its own feet, and at the end of the day, the figures that the Supreme Court mentions are as such. 3 lakh inquiries are initiated under the IMDT Act, which ultimately translates to less than 3,000 deportations finally. And this was facilitated to a very large extent by the scheme and the framework of the IMDT Act of 1983. So to address this and to tackle this particular issue, the Assam Students Union, through its then president and the current Chief Minister of Assam, Mr. Sarvanan Sonowal, they approached the Supreme Court, challenging the very existence of this legislation and saying that this is an unconstitutional piece of legislation which is resulting in the dilution and compromise of the dignity and the identity of the Assamese people. They approached the Supreme Court in 2000 through a writ petition before the Supreme Court directly. Now, the fact that politics has played a role in encouraging illegal immigration was even more clear and perhaps starker during the course of the proceedings before the Supreme Court, and I'll explain how. So since this is an issue that concerns illegal immigration with respect to a particular state, so the parties to this litigation were the Union of India, the state government of Assam, and the Assam Students Union. So when the petition was originally lodged before the Supreme Court, the party in power before at the center was the BJP. The party in power in the state of Assam was the Assam Gan Parishad, and then you had the Assam Students Union. Both the Assam Gan Parishad and the Union categorically say that this piece of legislation deserves to be repealed and struck down, and that this legislation is proving to be the greatest roadblock in the deportation of illegal migrants from the state of Assam. So an affidavit is filed on behalf of the state of Assam, or state government of Assam, clearly saying that this legislation needs to go. It's an unconstitutional piece of legislation. State elections are held in Assam, there is a power change, and then the Congress government comes into power in Assam. It wants to file a second affidavit and withdraw the first affidavit filed by the state of Assam to the line or to the effect that there is absolutely nothing wrong with the legislation at all, and that the legislation perhaps is the most perfectly constitutional piece of legislation that one could have witnessed. And no reasons are given as to why there is a sudden shift in position, a diametrical shift in position, as to how could a state government take a position which is so opposite to what it had previously said. It represents a lack of continuity. It represents a positive or a negative dissonance, so to speak. And yet the prayer from, or the request of the state government of Assam, then led by the Congress government, was that the second affidavit must be taken on record, and that its official position is that IMDT as a legislation does not need to be struck down at all. The Supreme Court says that we will take on record both the affidavits, and we will examine for ourselves as to whether or not this legislation is unconstitutional or not. The court categorically comes to the conclusion that this is the worst piece of legislation that could have been entered into, or that could have been brought into force, and that when the Foreigners Act was available, there was no need to introduce a new legislation and impose it on the state of Assam in particular. So this happens, and in the year 2005, the IMDT Act is struck down with two directions: that the government will take active measures to fence the Indo-Bangladesh border. So it's a 4,096 kilometer border with Assam sharing about 262 kilometers with Bangladesh. And despite the topography, one would have expected that in a span of 30 to 40 years, the government would have found the time, resources, inclination, and the energy to fence the border in a period of at least 40 years. We are talking of a span of about 262 kilometers. Somehow the government could not do so. The second direction that came from the government, from the Supreme Court, was constitute tribunals under the Foreigners Act to deport illegal immigrants and ensure that the process is expedited. Now again, so this decision comes out in 2005, by which time there is a change of dispensation in the center. The BJP has gone out of power and the Congress is in power. It's unfortunate that this discussion has to be dealt with on a political level as well, because politics has played perhaps the most pernicious role possible in stopping and proving to be a roadblock in illegal deportation. Therefore, this needs to be addressed. So 2005 or 2006, the Congress government is back in power. It comes out with a new set of rules under the Foreigners Act, which again proves to be a roadblock in the deportation. Therefore, the Assam Students Union again has to go back to the Supreme Court to challenge the new set of rules that have come under the Foreigners Act. That gets struck down again in 2006, and the Supreme Court recognizes for a fact that despite coming out with stinging, embarrassing observations in the first judgment of 2005, it's surprising that the government of India again adopts the same approach through the Foreigners Act now, and says that it is high time that the government took serious note of the effects, the devastating effects of illegal immigration. So one would have assumed that this would have had some kind of an impact on the government, because one would have hoped that the fear of God was put in them, that they had a semblance of a conscience, and they had an iota of integrity. But lo and behold, the proceedings before the Supreme Court still continue for a different reason. Now you have to understand that there are a few timelines that are relevant to this entire case. So there is a timeline from 1947 to 1966. There is a timeline of 1966 to 1971. And then there is a timeline of post-1971. Those people who entered as illegal immigrants between 1966 and 1971 were protected through a special provision, namely Section 6A of the Citizenship Act. Now, this particular provision was brought about again by the Congress government to protect the illegal Bangladeshis who had entered this country, or illegal East Pakistanis who had entered this country between 1966 and 1971. Therefore, again in the year 2009, I think it's in 2009, the Assam Sammilit Mahasangh approaches the Supreme Court challenging Section 6A of the Citizenship Act, saying, I've come to this court thrice, each time trying to impress upon the Supreme Court as well as the establishment that illegal immigration is eating into the vitals of this particular state. So that decision on Section 6A of the Citizenship Act was rendered on the 17th of December 2014 by the Supreme Court, where it comes to the view that Section 6A's constitutionality must be referred to a larger constitution bench. But be that as it may, illegal immigration is necessarily killing the culture of this land, and most importantly, is creating a security issue for the future as well. That is categorically recorded. And there are a host of directions that the Supreme Court issues to the central government, and it also identifies a number of issues to deliberate upon. This was a judgment, as I said, was delivered on the 17th of December 2014. By May 2014, there was a shift or change in power again in the center. Therefore, one would have hoped that the new dispensation would have taken this issue seriously and have volunteered to repeal Section 6A of the Citizenship Act, thereby taking away the blessing of citizenship on illegal immigrants. But the government continued to support that particular provision, and which resulted in the judgment of 17th of December 2014. That's not a final judgment because the constitutionality or the legality of the provision is yet to be decided upon. Be that as it may, the decision came out in December 2014 and we are in 2018. The direction of the Supreme Court to constitute a constitution bench to look into the constitutionality of Section 6A of the Citizenship Act is yet to happen. The court has had an opportunity to hear the matter for more than 27 dates or 27 hearings, so to speak. Nothing of consequence has happened. And this only makes us wonder whether the government itself takes its role as the protector of the nation state of India seriously or not. In this backdrop, you now have the Rohingya immigration crisis. At least with the Bangladeshi immigrants, the extent to which people could raise the bogey of human rights and refugee status was relatively less. However, with respect to Rohingyas, the chorus of human rights as an excuse to settle and rehabilitate these people on this particular soil has increased. If you take a look at the number of articles that have been written with respect to why Rohingyas must be settled in this country, it outnumbers the number of articles where people have legitimately argued that Rohingyas necessarily pose a security threat from a demographic standpoint as well. This more or less represents a shift in narrative, a change in narrative. Therefore, it is important for us to understand what the facts are and what the legal position is to separate the wheat from the chaff and to understand what is the actual truth behind all this noise. Therefore, let's understand the legal framework as far as refugees in India are concerned, because it becomes important to appreciate the position of people who are saying that these people need to go back. They don't have a legitimate right to stay in this country. India does not recognize the definition of refugee legally in any of its legislations. There is no legislation in this country that defines who or what is a refugee. What we have is an ad hoc procedure known as the Standard Operating Procedure, which was introduced on the 29th of December 2011 by the UPA government and continues to be adopted and followed by the NDA government even post 2014. Under this particular procedure, it is for the government to decide whether a certain group can be bestowed with the status of a refugee after undertaking due diligence with respect to any security threats that they may pose. Notwithstanding the fact that they may have come to this country through persecution or whatever it may be, the government reserves the right to decide whether or not somebody should be bestowed with the status of a refugee. Exercising its power under this standard operating procedure, the government of the day has come out with the categorical position that they do represent a security threat as far as India is concerned, and therefore they need to go back. The other side is basically of the view that India has obligations under international law to continue to host these people, and their arguments basically fall back on only one principle of international law, which is the principle of non-refoulement. But before I go to that principle, let me just explain one more aspect of the issue. As on date, India is not a signatory to the 1951 Convention of United Nations with respect to refugees, nor is it a signatory to the subsequent 1967 protocol. Consequently, India has no obligations, at least under these two international instruments, to treat these people as refugees as far as India is concerned. Since there is no obligation under these two instruments, the only question that remains to be answered is whether any principle of customary international law binds India and requires India and obligates this country to treat these people as refugees. That principle would be the principle of non-refoulement. The principle of non-refoulement broadly works in this fashion, which is to say, assume that Kashmiri, or rather Hindus from Pakistan come to India on the ground that they're being persecuted there, on the ground that they're being kidnapped and raped there. Then India cannot force them to go back to the same country where they're being persecuted, and in fact has an obligation to ensure that they're treated with dignity in this particular country. But that doesn't mean these people have the right to settle in this particular country. There is no right of settlement of any refugee as far as India is concerned, or for that matter any other country is concerned, because that is the determination and that is the power of the sovereign country itself to decide whether or not anybody has the right to settle in this country, particularly if he is a non-citizen. So as far as the principle of non-refoulement is concerned and its application to the Rohingya refugee crisis is concerned, it is our position that since we do not recognize the category of a refugee in this country, for all practical purposes, under the legal framework of India, Rohingyas are illegal immigrants and not refugees. Particularly since they pose a security threat and since the government has chosen not to give them the status of a refugee, they fall under the bracket of an illegal immigrant. Therefore, first of all, the principle of non-refoulement does not apply. Assuming the principle of non-refoulement applies, it is important for these people to be sent back, at least to the country of Bangladesh, because most of these people are coming from Bangladesh to India and not directly from Myanmar. Bangladesh is not the country which is persecuting Rohingyas. It is Myanmar which is persecuting Rohingyas. Therefore, India would not be in violation of the principle of non-refoulement if Rohingya Muslims are sent back to Bangladesh. One of the concomitants of the principle of non-refoulement also is that even if you're not in a position to host any refugee, you must at least share the burden in one way or the other. By sending humanitarian aid, by sending relief material, already India is doing enough to share its burden and to discharge its obligations with respect to Rohingya Muslims. It does not need to go a step further and invite them to stay in this particular country, particularly in light of the Bangladeshi immigrant experience. The most important thing that we have to understand is this. Of all the places where these people could have settled, a good number of them have gone and settled in Jammu. And this raises a serious question as to what is the design, what is the intent, who are the forces who are acting or who are pulling the strings as far as this particular situation is concerned. What strengthens our apprehensions are the reactions subsequent to the government's decision from political organizations, from Islamist organizations, from terrorist organizations who seem to have a vested interest in somehow housing these people in this country. It could be argued by some people that a number of 40,000 is really a small number compared to the population of this country, and therefore it should not matter to India. But then in a small flashpoint, or rather in a controversial flashpoint such as Kashmir, a number such as 40,000 is very, very potent. And what this number could translate to in the next 10 years, in the next 15 years, in the next 30 years is something that we cannot prognosticate or predict as on date. Therefore, it is only prudent for a country like India to be a bit more cautionary, to apply principles of caution and ensure that these people are sent back. I think what's very, very relevant as on date is that Myanmar seems to be open to taking back Rohingya Muslims from Bangladesh, and there are talks going on between these two countries to take these people back. If Myanmar can take Rohingya Muslims back from Bangladesh, why can't it take people back from India? And India seems to enjoy a fairly friendly relationship as far as Myanmar is concerned. Bangladesh is not the role model as far as India is concerned and cannot be the role model for the simple reason it calls itself an Islamic republic. And Rohingya Muslims are very clear that they are comfortable living only in Darul Islam. Consequently, there is at least no collision or, let's say, disagreement as far as worldviews are concerned between Bangladesh and Rohingya Muslims. And as history says, Rohingya Muslims are Bengali Muslims for all practical purposes. Therefore, we cannot cite Bangladesh as an example to shame India and to humiliate India and to emotionally blackmail India and say, Bangladesh is a poorer country, it's an overpopulated country, and since it seems to be in a position to host and house Rohingya Muslims, why can't India do so? It doesn't make sense for us to accept this argument at all. The other argument that is constantly thrown at us when this issue is raised or when this issue is discussed is, why is it that India objects to Rohingya Muslims being housed in this country or rehabilitated in this country on religious grounds? Our position is very, very simple. We have 1,000 years of historical experience to learn from. The change in demographics is already playing a huge role in various parts of this country, Kashmir being the most prominent example and the worst of examples possible. The existence of a democratic, pluralist, secular India is contingent on the demographic balance being maintained. It's as clear as that. And anything that upsets the demographics is not welcome. It's not possible for a sovereign government or a democratic government to ask a certain population or a certain community to breed less or to produce less. But it is certainly within the power of a democratic government of a sovereign nation to prevent external factors from influencing the demographics of this country. So I think it would be wrong on the part of India at this stage to go and tell any minority community or any community for that matter to produce less or reproduce less or procreate less. Or to say that you're breeding too much and you're causing a demographic inversion. That's something that the government cannot do at this stage at least. But the very least that the government can do is to prevent external factors which influence the demographic balance as far as India is concerned. Therefore, we need to learn from the Bangladeshi immigration experience, the devastating effect that it has had on the culture of the Northeast, on the law and order situation in the Northeast. In fact, I think a telling document in this regard would be the 42-page report of Governor S.K. Sinha, when he had made a recommendation to the Union government in 98-99 that the government needs to deport illegal immigrants from Assam on a war footing, and the kind of law and order issues it had created. In fact, there's even a better document. The 175th Law Commission report categorically recommends the creation of an anti-immigration force, so to speak, or setting up of a separate infrastructure to go after illegal immigrants on the similar lines as the immigration infrastructure that the United States of America has. There is a good reason for this. The official figures, if they are to be trusted, tell us that there are 2 to 3 crore illegal Bangladeshi immigrants in India. As usual, I think I would have to add another 50% or 60% to this official figure, and that takes us to a good figure of about 4.5 crores, who are spread across the country in parts of Tamil Nadu and whatnot. It's not possible for the government to deport all these people without having a dedicated infrastructure whose only job is to identify illegal immigrants and ensure that they're prosecuted for eviction. This is something that the government needs to do. Unfortunately, the sterling and stellar recommendations of the 175th Law Commission in this particular regard have fallen on deaf ears. No government, regardless of its stated ideology, stated position in its election manifesto, stated position during electoral speeches and whatnot, has taken the initiative to take illegal immigration seriously. We need to understand that after years of turmoil, after years of bloodshed, and after years of multiple holocausts that this subcontinent has seen, we finally have a unified, secular, democratic nation state in the form of India, which has a standing army of its own to protect the entire country. This is a blessing which we unfailingly fail to count. It's a blessing that we need to cherish, and it is something that we should not be taking for granted at all. And in turning a blind eye to the issue of illegal immigration, we do grave injustice to the concept of a nation state, to the sovereignty of India. In the recent past, I had the opportunity to attend a certain conference where the discussion was about nationalism, and somebody struck a distinction between patriotism and nationalism. I don't want to get into the nuances of the distinction between the two because perhaps I'm not qualified to comment on it, but this much I think is for sure. National identities are here to stay for the foreseeable future. We still haven't arrived at a situation where we can afford to have the state wither away. We still haven't arrived at a state where national identities and geographic boundaries have been rendered redundant. And there perhaps is no better example in the recent past than the Brexit example. National identities continue to matter, and I think good fences make for good neighbors. And that's the only way for us to ensure that the sanctity of this country is maintained, the sanctity of its borders are maintained. By failing to address the issue of illegal immigration, the sovereign state and the dispensation is perhaps throwing to the winds the most important responsibility of a sovereign state, which is to protect its borders. And therefore, the Rohingya crisis is not a news peg in itself, but it throws up multiple questions from the standpoint of security, from the standpoint of social fabric, as to how we choose to identify and define the concept of secularism, and how we choose to respect the concept of a nation state. Does India have a grand narrative which speaks of its own civilizational identity? All these questions are raised by the Rohingya crisis. And I think as opposed to trying to address this particular hole through using a bandage, or this particular leak with a bandage, India must use this opportunity to define for itself what it stands for, who it stands for, who is it willing to take in, and who it is not willing to take in as its citizens. These are issues that I think the government or the establishment has a wonderful opportunity to address. But I think I'm being perhaps a bit too optimistic, and I'm getting a bit ahead of myself, because I don't think that these issues are getting the due that they deserve from any quarter, from any arm of the state, be it the executive, the legislature, or even perhaps the judiciary. It's okay for us to be concerned about human rights. It's perfectly justified that we think of our grand old tradition of welcoming refugees. And I think nobody is saying that India must turn into a xenophobic nation. But I think at some stage, we must learn to put India first before anything else. And in getting into this wishy-washy, squeamish, mushy discussion of taking in all refugees of all hues, of all origins, regardless of their worldviews and regardless of the potential threats they could pose to this country, we are putting at risk and staking at risk our own livelihoods, our own safety, our own country. I think before 1947, this country was spread across the Arabian Sea to the Bay of Bengal, and this was supposed to be a united India. Let's call it the Akhand Bharat, even if it's a politically incorrect term. Post 1947, with religion playing such a huge role, we see a trifurcated India. At least post 1947, it's bifurcated. Post 1971, it's trifurcated for all practical purposes. Are we going to sow the seeds for further division of this country? Are we going to further sow the seeds for the next round of partition? Is a question that we have to ask and answer.